the trials are exciting. They give news flow. They give new disclosures. But the only question is this a serious threat to Google as a whole entity?
It is a serious threat. And the threat goes back to the experience with the Microsoft case, which the Department of Justice brought over 20 years ago. And the most important concept to come out of that case is that there are important limits on what a dominant enterprise can do by way of buying up inputs, channels of distribution that it and its rivals need in order to compete. And the theory that was endorsed by the Court of Appeals in that case is that a dominant firm can overreach when it basically seeks to preclude its competitors from getting effective access to users. And that core theory is the heart of this case. And I'm sure that's the theory that Google takes most seriously here in its defense.
William, you spent almost a decade as a non-executive director at the UK CMA, Competition and Markets Authority. Put your regulator hat on and tell us what chances you think US regulators have of a successful action against Google or Alphabet.
They have a fighting chance to demonstrate that there was an infringement of the law because of this core concept that is favorable to them. Obtaining relief that goes beyond prohibiting the specific conduct might be difficult. That's proven to be a very tough challenge in the United States. The other thing that will be difficult to cope with in the case itself is Google's response. In talking about the placement of the search engine on these devices, I suspect Google is going to ask the court, what would you have expected us to do otherwise? Should we have stood by and not even bid in the auctions that determined who was going to be on those devices? Should we have simply allowed our rivals to go ahead and obtain that precious real estate? What would you have had us do otherwise? And by implication, what should large firms do otherwise? I think that's going to be a hard issue for the court to wrestle with. But I'd say if I had to look at where the possibilities for success are, the government has a serious prospect of succeeding on the essential question of whether exclusivity was improperly obtained as a means of exclusion.
We had Rebecca Allensworth on yesterday, and thinking about sort of the concept of ultimately, even if they win or lose this individual case, ultimately the pendulum is swinging in the way in which regulators look at big tech. You yourself at the FTC, chairing it, of course, the agency from March 2008, 2009. Do you think conversations are permanently changed in the way in which regulators eye big tech?
I think there's been a durable change in the risk appetite that regulators in the United States, in the United Kingdom, as we were just mentioning before, take in looking at the sector. I think there was a fairly strong belief 20 years ago, going back to the documents that Leah was describing earlier. There was a sense that this is a very dynamic sector and that unpredictable changes you can't even identify at the moment, will deny any individual firm sustained preeminence in the field. Those assumptions have been revisited, and I think globally, you see a change from thinking, be cautious about intervening, to be willing to intervene, even though the specific outcome might be uncertain. And part of that strong belief is that simply having an active presence of the regulators chastens and limits the behavior of dominant firms.
And isn't it ironic that ultimately that moment, that unpredictable moment, is upon us? The fact that generative AI has swung into the mix and suddenly seems to be the most competitive threat to Google's search that we've had in a long time. So I'm interested as to the perspective that already in practice, do you think companies have been withholding from making purchases, withholding from perhaps making changes to the way in which they react to competitors because of the way regulators are now acting?
I think we're going to get some good insights in the trial on exactly that question. But I suspect that what companies have continued to look for are opportunities to achieve real breakthroughs of the kind that you were discussing in the previous segment with the Musk interview. I think there's no question that companies are looking for opportunities that will astonish by allowing them to achieve true preeminence in their own right. But a very difficult and almost unmeasurable issue in the trial is whether you advance innovation more by being aggressive in intervening or whether you advance it more by being more permissive.